If you're a naturalized U.S. citizen, there's one question that has probably crossed your mind this year, and it's not a small one. Can your citizenship actually be taken away? Curious. In 2026, immigration enforcement has intensified in ways that feel louder, faster, and more aggressive than anything we've seen in years. Files are being re-examined, background histories are being digitally cross-checked, old applications that once sat untouched in paper archives are now searchable in seconds. Social media is full of warnings. Group chats are buzzing with rumors about mass citizenship cancellations. Headlines are dramatic. Sighs. The anxiety is real. But here's the core problem. Fear spreads faster than facts. Before panic fills in the blanks, we need to slow down and answer the question the right way. What has actually changed? What is legally possible? And who, if anyone, is truly at risk? Because there is a massive difference between political messaging and constitutional reality. Understanding that difference can be the line between unnecessary fear and informed confidence. Hi, I'm Artur, and on Global Visa Guide, I break down complex immigration policy changes into clear, practical explanations so you can see exactly what applies to you and what doesn't. Today, we're going to unpack what's really happening in the 2026 immigration enforcement landscape, especially as it affects naturalized citizens. I'm going to walk you through what denaturalization actually is, why older citizenship files are being reviewed, who is being scrutinized, what your constitutional rights are, and most importantly, what you should be doing right now to protect yourself. This isn't about politics, it's about legal structure, process, and facts. When enforcement intensity increases, clarity becomes power. By the end of this breakdown, you'll know where you realistically stand, and where the rumors go too far. To understand what's happening in 2026, we have to separate something very important: the law itself versus how aggressively it's being enforced. Since returning to office in January 2025, President Trump has again made immigration enforcement a central priority. Executive directives have pushed for stricter compliance reviews, expanded fraud detection, and deeper audits of past immigration records. By early 2026, federal agencies began assigning more personnel and more digital resources to reviewing naturalization histories, especially in cases where there might be inconsistencies, criminal omissions, or suspected misrepresentations in the original application. That shift has understandably caused anxiety. But here's the key point. The law governing U.S. citizenship has not fundamentally changed. There is no new statute that suddenly makes citizenship easy to cancel. There is no executive order that allows agencies to revoke citizenship with a click. U.S. citizenship is protected by the Constitution. It cannot be taken away casually, administratively, or through a simple internal agency decision. This is where nuance matters. There is, and has long been, a legal process called denaturalization. It isn't new. It has existed for decades under federal immigration law. Denaturalization allows the government to seek the revocation of citizenship, but only under very specific circumstances, and most importantly, it requires a formal lawsuit filed in federal court. That means evidence must be presented before a judge. The government carries the burden of proof. The standard is high, clear and convincing evidence, and the individual has the full right to defend themselves with legal counsel. There is no secret administrative shortcut, no surprise letter that instantly erases your citizenship. Without a federal court case, there is no denaturalization. That structure has not changed in 2026. What has changed is the intensity of review and the technology being used. That's where the real shift is happening. Federal agencies are now using advanced digital cross-check systems that simply did not exist in this form a decade ago. Older naturalization applications, some filed 15, 20, even 30 years ago, are being digitally compared against criminal databases, travel records, asylum filings, visa histories, and other federal data sources. Paper archives have been scanned and integrated into searchable systems. Information that once required manual digging can now be flagged in seconds. If a name variation appears across documents, it can trigger a review. If a criminal charge existed before naturalization but does not appear in the application file, that discrepancy can now be detected far more easily than in the past. That technological evolution is one of the biggest reasons older cases are resurfacing in 2026. But here is the distinction that really matters. A flag is not a revocation. A digital alert is not a court judgment. It is simply a starting point for further review. For most naturalized citizens who were honest, met all eligibility requirements, and had no disqualifying issues at the time they applied, increased enforcement intensity does not automatically equal danger. Technology may be stronger, reviews may be deeper, but constitutional protections remain intact. If this clarification alone already makes things feel more grounded, stay connected. Because the goal here is simple: facts over fear, structure over speculation. And now that we've clarified what has actually changed, the next question becomes even more important. Who is truly being scrutinized right now? The answer is far more specific and far less dramatic than many online rumors suggest. So, who is actually at risk of denaturalization review in 2026? Not all naturalized citizens, not entire nationalities, not everyone who immigrated in a certain decade. Federal enforcement is concentrating on something much narrower and more technical. Whether citizenship was lawfully obtained at the time it was granted. That distinction changes everything. Denaturalization does not focus on what you did after becoming a citizen. It focuses on whether there was fraud, concealment, or material misrepresentation during the immigration or naturalization process itself. One major category, drawing renewed scrutiny, involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, especially offenses that would have affected eligibility. The key words here are serious and pre-naturalization. Minor traffic citations are not the target. Forgotten parking tickets are not the issue. What investigators look for are undisclosed arrests, convictions, or criminal conduct that, if revealed, would have legally blocked approval. Another category involves identity inconsistencies, situations where different names, dates of birth, or biographical details appear across visa filings, asylum applications, green card petitions, or foreign records. In some cases, these inconsistencies are innocent errors. In others, they raise questions about intentional concealment. That difference matters, and intent becomes central in court. Marriage-based green card histories are also under review in certain situations. If permanent residency was originally obtained through a fraudulent marriage, and that residency later led to citizenship, the entire chain can be examined. Again, the question is not whether someone eventually became a productive citizen. The legal question is whether the foundation was lawful at the time it was created. There is also attention on cases involving undisclosed affiliations with organizations that could have made a person inadmissible during the original process. These categories are not new in 2026. They have always existed in immigration law. What's new is the level of digital cross-checking making discrepancies easier to find. Here is where fear often replaces facts. Not every mistake is fraud. The law requires that any misrepresentation be material. That word carries enormous legal weight. Material means significant enough that, if the truth had been known, citizenship would not have been granted. A typo on a form is not material. A short, forgotten trip abroad is not material. A minor offense that did not affect eligibility is not material. The government must show that the alleged concealment actually mattered to the outcome. That is a high bar. So, what happens if you're contacted? This is where understanding your rights becomes critical. If a federal agency believes there was fraud in your naturalization process, it cannot simply cancel your citizenship inside an office. It must file a civil lawsuit in federal court. That is step one. Without a federal court case, There is no denaturalization. Once a case is filed, you have the right to respond. You have the right to hire an attorney. You have the right to review the evidence presented against you. You have the right to challenge that evidence and present your own. And the burden is entirely on the government. You do not have to prove you deserve citizenship. The government must prove you were never legally entitled to it in the first place. Denaturalization proceedings are civil, not criminal. That means the standard is clear and convincing evidence, lower than beyond a reasonable doubt, but still demanding. However, if fraud or false statements are alleged, separate criminal charges can sometimes arise in parallel. That's why early legal representation isn't just helpful, it's strategic. If you're contacted informally, through a letter requesting more information or even an unexpected visit, you are not required to answer detailed questions without counsel. You can calmly state that you wish to consult an attorney before responding. That is not an admission of guilt. It is the exercise of a constitutional protection. You also have the right to appeal. If a federal court rules against you, the process doesn't automatically end there. Higher courts can review whether the law was applied correctly and whether constitutional safeguards were respected. And importantly, if the government fails to meet its burden of proof on a specific allegation, it cannot endlessly retry the same claim without new evidence. The judicial system includes protections against abuse of process. If this explanation is already helping you feel more grounded in legal structure rather than online panic, stay with me, because next we need to confront the biggest myths circulating right now: claims about mass deportations, dual citizenship bans, and certain countries being targeted. Once we separate those rumors from reality, the 2026 picture becomes much clearer. Let's address the rumors directly, because misinformation spreads fastest when emotions are high. One of the biggest claims circulating in 2026 is that naturalized citizens are being mass deported. That is not accurate. Even with increased enforcement and more investigations, denaturalization cases account for an extremely small fraction of the millions of naturalized citizens in the United States. These are individualized legal actions based on specific allegations tied to a person's original application, not broad sweeps aimed at entire communities. The word mass generates clicks, but it does not match the legal reality. Another rumor says that speaking your native language, traveling back to your home country, or maintaining dual citizenship somehow puts you at risk. That is false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language at home. You can visit family abroad. You can maintain ties to your heritage. In many cases, dual citizenship is permitted if your country of origin allows it. None of those factors automatically trigger denaturalization. Citizenship is a legal status, not a cultural loyalty test. There is also confusion around criminal conduct. Here's the distinction that matters. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Deportation is a consequence applied to non-citizens. A citizen cannot be deported unless their citizenship is first revoked through the court process we discussed. Timing is critical. Criminal conduct becomes relevant to denaturalization only if it existed before naturalization and was concealed in a way that would have affected eligibility. That is very different from committing an offense years after becoming a citizen. Again, the focus is on whether citizenship was lawfully obtained at the time, not whether someone has lived a flawless life afterward. Another claim online is that citizens from certain countries are being unofficially targeted for citizenship review. There is no public statute or formal directive that strips citizenship based solely on national origin. Denaturalization demands individualized evidence tied to a specific person's file. While broader enforcement priorities may focus on particular regions for visas or border policy, revoking citizenship requires case-by-case proof in federal court. Ethnicity alone is not a legal basis for denaturalization. Some newer applicants also worry that because interviews have become more detailed in 2026, Previously approved citizens could randomly be called back and retested under new standards. That is not how the system operates. Naturalized citizens are not routinely re-interviewed simply because procedures evolve. There must be a specific trigger, an inconsistency, new evidence, or investigative findings tied to the original process. Political rhetoric can sound sweeping, but the legal framework underneath it is narrower and more structured than many assume. So where does this leave you right now? Not in panic, in preparation. If you are a naturalized citizen who disclosed your history honestly, met all eligibility requirements, and completed your process lawfully, your citizenship remains one of the strongest legal protections available under U.S. law. That constitutional foundation has not disappeared in 2026. But stronger enforcement does mean preparation matters more than it once did. The first practical step is organization. Keep copies of your naturalization certificate, prior green card records, and your original applications, including supporting documents. Maintain both digital backups and physical originals in a secure place. If questions ever arise, documentation becomes your strongest ally. Second, if your immigration history included complex elements, prior overstays, name variations, past charges, or multiple filings under different circumstances, consider scheduling a confidential review with an experienced immigration attorney. Not because you are automatically in danger, but because clarity removes uncertainty. When enforcement intensity rises, knowing exactly where you stand provides stability. Third, respond promptly to any official correspondence. If you ever receive communication referencing your naturalization, do not ignore it. Do not assume it's a mistake. Do not try to navigate it alone. Early legal guidance can prevent small issues from escalating. Silence rarely resolves legal questions. It usually makes them harder. For green card holders watching this, your situation is a bit different. Permanent residents do not have the same constitutional shield that naturalized citizens enjoy. Status can be revoked more easily if serious violations occur. That makes compliance essential. File your taxes consistently, stay away from criminal conduct, maintain continuous residence, and apply for citizenship as soon as you're eligible. Citizenship is not just symbolic, it is structural protection. Immigration policy in the United States has always moved in cycles. Enforcement expands, courts review, political winds shift, legal challenges narrow or reshape executive actions. That pattern has continued throughout 2025 and 2026, with several new measures facing judicial scrutiny. The system of checks and balances is still active. Executive authority has limits. Courts impose standards. Due process still governs outcomes. Technology has evolved. Data systems are more integrated. Historical inconsistencies are easier to detect. That is real. But constitutional safeguards are real too. Preparation is power. Knowledge creates stability in environments that feel uncertain. If this breakdown has helped you replace rumors with structure and fear with facts, share it with someone who needs clarity right now. Many people are reacting to headlines without understanding the legal framework behind them. Stay informed from reliable sources and make sure you're subscribed to Global Visa Guide so you don't miss future updates as policies continue to evolve through 2026. And if your situation involves unique complexities, consult a licensed immigration professional who can evaluate your specific case. No video can substitute for individualized legal advice. Millions of naturalized citizens continue to live, work, vote, build businesses, raise families, and contribute across every sector of American society. Enforcement priorities may shift, but lawful citizenship remains one of the strongest legal statuses in this country. Stay informed, stay prepared. And as policies develop, I'll keep bringing you clear, fact-based updates so you can move forward with confidence instead of confusion.